Welcome back to UK Knowledge Guru. In this video, we will discuss the guidance which is provided by the gov.uk. So we will discuss what is Windrush Scheme, a quick overview, and then we will discuss how applications will be considered. So this is the guidance provided by the gov.uk, and then we will discuss what applications will be considered under the Windrush Scheme. So they have provided a full details, if a person in the UK, if a person outside the UK. So they have provided all the guidance over here, and then they have also provided the list of Commonwealth countries, which countries are eligible for this scheme. So without wasting time, let's start. So the people who arrived in the UK many years ago and do not have proof of their immigration status have faced difficulties in proving their right to work, to rent property, and to access benefits and services to which they are entitled. The government apologized to the people, and in this scenario they mention that they will help them once they provide their proof of immigration status. On 16th 2018 of April, the Home Office established a task force. That task force known as Windrush Help Team to make immediate arrangement to help those who needed it. This includes setting up a helpline, so you can contact Home Office directly and the Home Office will help you. Now let's discuss how to apply. To apply this, you need an application under the Windrush Scheme must be made on the relevant form on gov.uk. Later on, I'll show you how to submit that application. Windrush Scheme application UK for applicants living in the UK, or the Windrush Scheme application overseas for applicants living outside the UK. You don't need to pay any fees because it's free. You just need to do your biometrics and photograph. Now let's discuss how applications will be considered. So for that, the Home Office guidance says an application under the Windrush Scheme will be considered under existing law and policy. But if policy set out in this document differ from existing policy, this document will be applied. The Windrush Help Team will consider the application in the round based on all the available evidence, including from Home Office records and those of other government departments. No information provided in relation to an application under the Windrush Scheme will be passed on to the immigration enforcement. The Windrush Help Team will not consider any application which falls outside the scope of the Windrush Scheme as set out in this document. Definition of the nationalities and groups included under Commonwealth citizen for the purpose of this scheme is included at the end of this document. Later on in this video, I'll show you the list of all the countries which are eligible. Now let's understand what applications will be considered under the Windrush Scheme as per the Home Office guidance. So first we will discuss when a person in the UK. If a person in the UK, a Commonwealth citizen who was either settled in the UK before 1st January 1973 and has been continuously resident in the UK since their arrival, or has the right of abode. In that case, the Windrush Help Team will consider whether the applicant is already a British citizen, and if they are, they will be given a document confirming that. If the applicant is not British citizen in that case and has said on the application they want British citizenship, they will consider for naturalization under the British Nationality Act 1981. Applicants who were settled in the UK on 1st January 1973 and those with right of abode who have strong ties to the UK will be taken to have sufficient knowledge of English and of life in UK test, and so requirement to pass the life in UK test will not apply to them. They will also not have to attend citizenship ceremony unless they want to. The applicant will have to meet the residence requirement for citizenship and the good character requirement. If the applicant qualifies for British citizenship, they will be given certificate of naturalization. If the applicant does not apply for British citizenship or does not qualify for naturalization, the Windrush Help Team will consider whether they have the right of abode, and if so, they will be given a document confirming their right of abode. If not, the Windrush help team will consider whether they are entitled to remain in the UK, and if so, they will be issued a grant of no time limit, which we call that NTL. Now let's discuss the second part, a Commonwealth citizen who was settled in the UK before 1973, whose settled status lapsed because they left the UK for a period of more than 2 years, and who is now lawfully in the UK and has strong ties to the UK. In that case, if the applicant is currently lawfully in the UK and not liable to deportation on grounds of criminality or other non-conducive behavior and has strong ties with the UK, they will be given ILR. Due to mistake in previous versions of Home Office guidance, some applicants who lost settled status as a result of an absence of more than 2 years prior to 1st August 1990 and who returned to the UK on some other form of limited leave by that date and have lived in the UK continuously since may previously have been issued a no time limit document despite not actually having ILR in law. Where such cases are identified, they should be treated as failing under this eligibility group of the scheme and will be considered for a grant of ILR. Further, the Home Office guidance says if the applicant is already settled in the UK and wants British citizenship, they will be considered for naturalization under British Nationality Act 1981 in accordance with the residence and good character requirement. Applicants who were settled in the UK on 1st January 1973 will be taken to have sufficient knowledge of English and of life in the UK, and so the requirement to pass the life in the UK test will not apply to them. They will not have to attend a citizen ceremony unless they want to. Now let's try to understand when a child of a Commonwealth citizen parent where the parent either was settled in the UK before 1st January 1973 or has the right of abode and was ordinarily resident in the UK on that date or did not satisfy this provision and is now a British citizen, including those who satisfied one of those requirements and is now deceased, and where the child either was born in the UK or arrived in the UK before the age of 18 and was not automatically a British citizen or a citizen of the UK and colonies from birth and has continuously resident in the UK since their birth or arrival. Number 2, was born in the UK or arrived in the UK before the age of 18 is a British citizen and automatically became a British citizen of the UK and colonies British citizen at birth. Further, the Home Office guidance says where the parents died before 1st January 1973, it is sufficient that they were settled in the UK before their death. The Windrush help team will consider whether the applicant is already a British citizen and if they will be given a document confirming that. If they are not, the applicant has said on the application that they want British citizenship. The Windrush team will consider whether the applicant has the right to register as a British citizen under the British Nationality Act 1981. If they do, they will be given a certificate of registration. If they are not entitled to register as British, they will be considered for naturalization under the British Nationality Act 1981. Applicants whose parent was settled in the UK before 1st January 1973 or those whose parent has a right of abode who had strong ties to the UK will be taken to have sufficient knowledge of English and life in UK, and so the requirement to pass the life in UK test will not apply to them. They will also not to have attained citizenship unless they want to. the applicant will have to meet the residence requirements for citizenship and the good character requirement. Now let's discuss if the applicant qualifies for British citizenship. They will be given a certificate of naturalization as per the gov.uk Home Office guidance. If the applicant does not apply for British citizenship and does not qualify for naturalization, the Windrush help team will consider whether they have the right of abode, and if so, they will be given a document confirming of the right of abode. If not, the Windrush help team will consider whether they are settled in the UK, and if so, they will be granted of time, no time limit. If not, they are lawfully in the UK and not liable to deportation on grounds of criminality or other non-conductive behavior. They will be given ILR. Now let's discuss a person of any nationality who arrived in the UK before 31st December 1988 and is settled in the UK. In that case, the Windrush help team will consider whether the applicant is already a British citizen, and if they are, they will be given a document confirming that. If the applicant is not British, the Windrush help team will consider whether they have the right of abode, and if so, they will be given a document confirming the right of abode. If not, the Windrush help team will consider whether they are settled in the UK, and if so, they will be issued grant of no time limit, which is also known as NTL. Now let's discuss the most important part, which is when a person is outside the UK. In that case, a Commonwealth citizen who was settled in the UK before 1st January 1973 but who does not have a document confirming their right of abode or settled status, or whose settled status has lapsed because they left the UK for a period of more than 2 years. In that case, the guidance clearly says the Windrush help team will consider whether the applicant has the right of abode, and if so, they will be given a certificate of entitlement to the right of abode. If not, the Windrush help team will consider whether the applicants meet the requirement for returning residence under the immigration rules. Further, the guidance says if so, and the applicant states on the application that they want to return to the UK permanently. In that case, they will be granted a returning residence visa. On returning to the UK, a returning resident can apply to naturalize as British citizen only after they will be living or resident in the UK further 5 years. 3 years if they are spouse or civil partner of a British citizen. They will not have to attend a citizenship ceremony unless they want to. Further, the guidance says if the applicant qualifies as a returning resident but states on the application that they want only to visit the UK, in that case, the Windrush help team will consider whether they also meet the requirements for a visit visa under the immigration rules. And if so, they will be granted a 10-year multiple entry visit visa, which will allow them to visit the UK for up to 6 months at a time within that 10-year period. Now let's discuss the meaning of Commonwealth countries. Which countries we are talking about who is eligible for consideration under the Windrush scheme. There's a long list you can see in front of your screen. So for example, if you are from Bangladesh, Australia, Brunei, Canada, Ghana, Hong Kong, India, Kenya, Malaysia, Maldives, Malta, New Zealand, Pakistan. So it's a long list you can see in front of the screen. So if you are from any of these countries, then you are eligible. Further, the guidance says, in addition, the following people are included. Number 1, citizens of the UK and colonies by virtue of connection to a country or territory on the above list. Number 2, British subject without citizenship under the law on 1st January 1973. Now let's discuss the last part, meaning of parent, for the purpose of who is eligible for considering under the Windrush scheme. The definition says this has the normal meaning under the immigration rules. However, where there has been genuine transfer of parental responsibility on the ground of original parent inability to care for a child for the purpose of the Windrush scheme, the definition may include a child born outside the UK.